our next panel, it is my honor to introduce the Honorable Chad Readler. Judge Readler earned his undergraduate and law degrees at the University of Michigan. After graduating, he served as a law clerk to Judge Alan Norris of the United States Court of Appeals for the Sixth Circuit. Judge Readler then began practicing law in the Columbus office of the international law firm of Jones Day, eventually spending 10 years as partner in the firm's Issues and Appeals Practice Group. While at Jones Day, Judge Readler appeared in state and federal trial and appellate courts around the country, most frequently the Supreme Court of Ohio and the Sixth Circuit. Judge Readler also successfully argued before the United States Supreme Court in McQuiggan v. Perkins on behalf of an inmate claiming actual innocence. His other pro bono representations include representing capital defendants before the 10th Circuit and the Supreme Court of Ohio, as well as representing defendants sentenced to life in prison before the Sixth Circuit. And while at Jones Day, Judge Readler traveled to Nairobi with Lawyers Without Borders to train Kenyan lawyers in prosecuting domestic violence cases. He was also a recipient of the American Marshall Memorial Fellowship awarded by the German Marshall Fund of the United States. Following his career in private practice, Judge Readler served as acting Assistant Attorney General in the Civil Division of the United States Department of Justice from 2017 to 2019. And in that role, Judge Readler led and supervised a team of over 1,000 lawyers in the department's largest litigating division, briefing and arguing several cases on behalf of the United States in federal courts across the country, including high-profile cases significant to the administration and the department. In March 2019, Judge Readler was confirmed to serve as a circuit judge on the Sixth Circuit. I know that we will benefit from Judge Readler's expertise and insight on this panel today, and please join me in giving him a warm welcome.
Thank you for the very nice introduction. I hope you benefit from my appearance. I'm benefiting from being in Florida, so it's quite cold in Ohio right now, so thank you very much for having me. In all seriousness, this is actually a conference I've wanted to attend for many years. We now have a statewide conference in Ohio, but I think the reason we have that is because of the success of the Florida conference, which really started off the notion of having statewide conferences with the Federalist Society. So I think of you as all the founding fathers in this respect. So thank you for your efforts to promote state conferences across the country, including in Ohio. So, it's common to say we have experts on a topic and they're going to talk about today's topic for you, but this is really a preeminent group. I can't explain to you enough how pleased I am to be with these true experts about presidential power. We have 3 alums of the Office of Legal Counsel at the Department of Justice, and we have the acting Solicitor General. So I think you're really in for a treat over the next hour plus. Let me introduce our panel, and let me say a couple of introductory remarks about maybe some of the things they're going to cover and kind of give you a little insight into how the Department of Justice works, and then I'll turn it over to them. So moving from this end of the table to the other end, I'll start with Steve Engel. Steve is a partner at Dechert LLP, where he serves as an advocate in high-profile trial and appellate matters. He previously served as the Assistant Attorney General for the Department of Justice's Office of Legal Counsel. While serving at DOJ, Steve was awarded the department's highest honor, the Edmund J. Randolph Award, for outstanding service to the department. Steve clerked on the United States Supreme Court for Justice Anthony Kennedy. Jack Goldsmith is the Leonard Hand Professor of Law at Harvard Law School. He has written many books and hundreds of articles and essays on topics related to presidential power, national security, international law, and internet policy. Before joining the Harvard faculty, Jack also served as Assistant Attorney General for the Office of Legal Counsel and as Special Counsel to the Department of Defense, and he too clerked for Supreme Court Justice Anthony Kennedy. Sarah Harris is the Acting Solicitor General at the United States Department of Justice. There, she represents the United States before the United States Supreme Court. Before returning to the department, Sarah was a partner and Supreme Court litigator at Williams & Connolly. She previously served as a Deputy Assistant Attorney General in the Department of Justice's Office of Legal Counsel, and Sarah clerked for Supreme Court Justice Clarence Thomas. And we were so thrilled to have her, given everything that's going on at this moment at the department. But in light of her current service, I imagine there are some topics she won't be able to discuss as robustly as maybe the rest of our panelists. And let me just say, I'm a little embarrassed. My introduction was about 3 times as long as theirs. And these are really the distinguished folks up here on the panel. But in the interest of time, let me just give you a little background on what I view as the importance of the Office of Legal Counsel. And I come at that from someone who served in the department with Steve and Sarah as the acting head of the Civil Division. So the Civil Division is 1,000 lawyers in Washington responsible for handling most of the high-profile cases involving an administration and the top sort of policy matters that are in litigation at the department. But OLC is really the part of the Justice Department and of the executive branch more broadly that really solves a lot of legal problems facing the executive branch. So the Department of Justice gives binding legal advice across the executive branch, and that really starts first and foremost at the Office of Legal Counsel, or OLC. You've probably heard of OLC memos, the way that OLC gives sort of formal advice through the memo process. But anybody in the executive branch, from a cabinet secretary to the White House, if they have a legal question they're pondering, the place they go to get, again, binding advice is the Office of Legal Counsel. And so any policy, before it goes into, our experts can tell you more, but before any policy goes into effect, an executive order is issued, an agency passes an important rule or regulation, they're getting advice from OLC on the legality of what they're doing. And so for someone who had to litigate issues once they were introduced, I so appreciate OLC for solving many of the problems before they became litigation problems. They couldn't solve them all because we had to go in front of judges, and they might have a different view than the OLC and executive branch. But these are 3 people who have just seen policy and presidential power issues at the very, very highest level. So I'm thrilled to be with them this morning. I think they're all going to start with maybe 5 or 6 minutes about some current issues in presidential power. Then I'll have some questions, and then hopefully we'll have time for questions from all of you. So Steve, do you want to start?
Sure. Thanks, Judge. It's nice to be here with this distinguished panel, as well as everyone else who woke up early on a Saturday morning to talk about topics in executive power. Over the past 2 decades, we have seen a Supreme Court that's increasingly interested in taking the Constitution's separations of powers seriously, and that shift has become only more pronounced in recent years since President Trump put 3 strong nominees on the court who have built a durable majority on these issues. It's also a good time to talk about executive power because with the recent presidential transition, we've closed the book on President Biden's first term, and we're in a position to evaluate the impact that his administration had on executive power. We're also, I think, at this point, in a position to say a few words on what is a really ambitious agenda of President Trump's second term, as we've seen over the last couple of weeks. Starting with the Biden administration, although President Biden may not have publicly trumpeted his views on executive power, his administration, in fact, advanced a very aggressive view of the president's power to unilaterally solve the nation's problems. He came into office by seeking to wield the executive's emergency authorities to address the COVID pandemic. And that led the administration, notably and somewhat controversially, to impose things like the vaccine mandates and the mask mandates in similar measures in the first year of his administration. But those regulatory efforts were not limited to COVID. The Biden administration pushed unprecedentedly broad regulatory mandates across the broader economy. Some of them he turned to COVID to facially justify those issues, like his proposal to forgive $400 billion in student loans, purportedly justified by the pandemic. But the regulatory program went much further. Across a range of departments and agencies, President Biden sought to pursue progressive policy goals through the use of the power of the administrative state. And so it's a very long list, but we saw regulations involving greenhouse gas regulations on power plants and on automobiles, DEI initiatives, net neutrality, the regulation of cryptocurrencies, non-compete clauses in the 50 states, in employment contracts. And in these areas, the Biden administration invoked, largely they relied heavily upon the Chevron doctrine, which held that federal courts should defer to an administrative agency's own interpretation of ambiguous and often open-ended federal statutes. And so the theory would be that when the agency adopts a regulation and when it arguably fits within the parameters of the statute, the agency should win. Although the Biden administration was about as aggressive on the regulatory front as any administration that I've seen, its ultimate record in the courts and therefore the impact on executive power was not quite as good. When these broad regulations were challenged in court by industry groups, by states' attorneys general, and a great many of them were, the Biden administration lost most of the time. And not only did they lose in the sense that the particular regulation was held to be invalid, but the Biden administration produced a reaction in the federal courts, and notably the Supreme Court, that significantly cut back on the powers of the administrative state, which ultimately is the power of the president and the executive branch to adopt policy goals without express statutory authorization. And so, for example, the Supreme Court formally adopted the major questions doctrine in cases like West Virginia versus EPA and Biden versus Nebraska, where the court held that administrative agencies could not rely upon vague statutory delegations to adopt regulations of vast economic and political significance. And then famously, the Biden administration's regulatory efforts also produced the final death knell of the Chevron doctrine. After the Supreme Court knocked down a number of regulations as contrary to law, the court in Loper Bright took the additional step of holding that federal courts should no longer defer to administrative agency interpretations of purportedly ambiguous statutes. And taken together, these decisions cut back on executive power for the Biden administration and future presidential administrations from relying upon these broad and open-ended statutory delegations to agencies. Now, although the court rebuffed the Biden administration's efforts to rely upon executive power to regulate the economy, the court's recent decisions did strengthen the hand of the president when it comes to executive power as exercised in controlling the executive branch itself. In a series of decisions, the court in recent years has confirmed that the Constitution vests all executive power in the president, and that the rest of the executive branch must be accountable to him. In so doing, the court chipped away at earlier decisions such as Humphrey's executor and Morrison versus Olson that had permitted Congress to fragment executive power and therefore weaken the hand of the president in seeking to pursue his elected agenda. The court, emphasized the president's central role in cases like Seila Law and Collins, which struck down statutes that had prevented the president from removing executive officers. And the court also made a similar move in cases like Lucia and Arthrex, which emphasized that every officer of the United States, every person holding an office with substantial executive power, must be appointed and therefore be accountable directly or indirectly to the president. Now, the Biden administration didn't always push for a unitary executive before the Supreme Court, but President Biden did push that power in a number of cases when it promoted the policy goals of his administration. So, for example, in a shift from past practice, when he came into office, he removed the NLRB's general counsel and the Social Security Administrator, officers who had traditionally served out their terms across administrations. He also removed Trump appointees from presidential commissions and caused the removal of at least one career SES official because of essentially policy disagreements. Now, I cite some of these examples of President Biden's use of executive power because what we've seen in recent weeks, that President Trump has come in and pushed hard to continue this trend toward consolidating the authority of the president in the executive branch. The Trump administration has sort of notably come in with a whole series of muscular executive actions, many of which involving executive orders that perhaps we'll talk about this morning, but also on the personnel front, where the president has terminated inspectors general, members of the NLRB and the EEOC, among other positions, by invoking his authority under Article 2. And, we've also seen the Trump administration continue these aggressive efforts to consolidate authority in the civil service as well. And, while I think some of these issues may well be challenged, may well be put in front of the courts in the months to come, my guess is that President Trump will win a lot more than he loses, and that the net result of these actions will be to further consolidate executive power, within the president. So, with that, I look forward to talking about these questions with the panel.
Great, thank you, Steve. Jack?
Thanks so much, Judge, and thanks everybody. I'm delighted to be on this distinguished panel. I'm going to talk about Trump versus United States. the immunity decision from last term. I think that this decision may be the most consequential decision that the court has yet announced on the scope of presidential power, at least with regard to domestic presidential power. I think it will come to be seen as a precedent that, so Youngstown is typically thought to be the kind of canonical case that through which we understand the president's powers, and especially through Justice Jackson's third category. And I think that Trump versus United States will eclipse that, and I think it has extraordinary implications that not all of which have been fully fleshed out. I'm not going to be able to do that in my 7 minutes, obviously. So I'm just going to say a few things about the opinion. First, I just want to emphasize what an unusual case it was, the arrangement of the case. You had the current president prosecuting the former president. You had both parties making broad claims of presidential power. The Biden administration, the special counsel, was arguing and it had invoked the president's broad discretion to prosecute, and it argued, to be sure, that the former president lacked immunity from this broad prosecutorial power. But at the same time, in the Supreme Court, the special counsel went out of its way to emphasize all of the many protections that a former president had from prosecution. And the reason the special counsel had to do this was because, one, it knew that the court would be concerned about that. But two, as Michael Dreeben, the attorney said for the special counsel at oral argument, said, the special counsel had a dual role and that there were conflicting equities. On the one hand, the special counsel wanted to prosecute the former president, thought that it had the proper predicate to do so, thought that there was no immunity. On the other hand, the special counsel had the duty to ensure that presidents going forward were protected from inappropriate prosecutions. So in the course of the special counsel's brief, and this was the dominant theme in oral argument, there was a broad discussion of all of the many ways that the president had protections from criminal prosecutions. And extraordinarily, these issues really weren't fleshed out below. This was the question about whether Congress could, the circumstances in which Congress could regulate the presidency through criminal law. None of these issues were addressed by the courts below. So and then on the other side, on President Trump's side, you had broad claims of presidential power and broad claims that any prosecution of a former president would have detrimental effects on a sitting president. So it was a strange case in which broad assertions of presidential power were being waged along a variety of dimensions. As you all know, the court ruled that the president is absolutely immune from prosecution for under criminal laws that touch on the president's exclusive power, and that the president was at least presumptively immune from prosecutions subject to a kind of burden test for prosecutions that concern his concurrent powers with Congress. And so everybody has focused on, and there was a lot of catastrophizing, in my opinion, about the implications of the immunity part of the ruling. For me, that's not the important part of the ruling. The immunity holding itself, the fact that the president had the immunities I just described, was not the important part of the opinion. I actually think that's not going to have a large impact on the presidency. I could be wrong about that. It was the predicates, it was the underlying analysis of the scope of presidential power that underlay that immunity that's going to be so consequential. And I just want to talk about 2 or 3 elements of that. First of all, the court held that because of the president's removal power, the president could not be prosecuted for threatening to remove the acting attorney general as part of an alleged scheme to obstruct a congressional proceeding, i.e., Congress cannot criminalize a president's threats against the attorney general to further a scheme that would otherwise, by allegation, violate a criminal law. Because of the threat to remove the attorney general, the court said that implicated the removal power and that was unconstitutional and the president could not be prosecuted for that. this is a novel understanding of the scope of the removal power. The removal power, as best I can tell, I'd love to be corrected, has been limited to cases where either there's a for-cause provision that the president's trying to resist, or an insistence that another branch of government, primarily the Senate, has to have a role in the removal. So this was a novel holding extended to a novel context, the implications of which are not yet clear. Second, and much more importantly to my mind, the court held that the president, and this, as best I can tell, is a novel holding with potentially very broad implications, that the president has the exclusive authority and absolute discretion over which crimes to investigate and prosecute. Let me say that again. The exclusive authority and absolute discretion over which crimes to investigate and prosecute. And therefore, because the president was allegedly trying to, according to the allegations, advise/coerce the Justice Department to engage in an investigation that was allegedly fraudulent in order to further a scheme of obstructing a congressional proceeding, because that took place, because he was being prosecuted for the act of exercising prosecutorial discretion and investigatory discretion, the president could not be prosecuted for that. And the scope of that is potentially very broad. It means that, it seems, any order by the president concerning investigation and prosecution, and to my mind, and I won't get into the details, not just criminal enforcement, but civil enforcement as well, that the president has, according to the Supreme Court, exclusive power over those choices. This is a novel holding with, the take care clause is a clause with multitudinous meanings. Take care clause is the clause that binds the president to law. The president has a duty to comply with the law because of the take care clause. The president's authority to interpret law flows in part from the take care clause. And the president's authority to enforce law, including the president's discretion to enforce law, flows from the take care clause. And the Supreme Court in this case for the first time said, they'd said this in dicta in U.S. versus Nixon in a case that had nothing to do with this issue. For the first time said this was an exclusive power that could not be regulated by Congress. And this, I'll just say, this has potentially huge implications for the scope of presidential power. If the court meant that, I'm not sure it did. I'm not sure it meant for this principle to have legs. Just to take one example, if I'm speaking for myself, if I'm defending the president's decision not to enforce the TikTok ban, I'm going to be citing this provision of Trump versus United States, saying the president has the exclusive authority over the discretion about which laws to enforce. I think I'll leave it there. I'll just also say one last thing. What was left of Morrison versus Olson, or at least one slice of what was left of Morrison versus Olson, is pretty clearly gone by this decision. Did I write this down? Yeah, Morrison, I'll end with this. Morrison said that Congress can reduce the amount of control or supervision that the Attorney General, and through him, the President, exercises over the investigation and prosecution of cases. That Congress can reduce that control. That is clearly overruled. That is clearly inconsistent with Trump versus United States. So that's a third important element of the case. I think that we're going to see Trump versus United States being invoked a lot in the next 4 years, and I think that the contours of the decision will be fleshed out. Thank you.
Great, thank you, Jack. Sarah.
Thank you guys for having me. I will start off with a disclaimer. I am speaking here only in my personal capacity. I don't speak for the United States, and therefore I will be your most boring speaker. I will not be offended if you use this time to check your phone, although I do hope to convince you just sort of at a 40,000 foot level to take a step back. Why should you care about the separation of powers? You evidently do, because you're here at like 9:30 on a Saturday, so that's very encouraging for those of us who kind of live and breathe separation of powers issues. But I think it's worth kind of taking a step back and thinking, like, why do we have this system? Why do we have this kind of rock, paper, scissors type system of Congress, the president, and the courts kind of checking each other? Why do we have a system of defined powers, but also overlapping powers, expending a lot of effort to figure out whose power is exclusive vis-a-vis the other, and what can each other do to check the others? I mean, it really is because our system is designed to have these kinds of checks on the branches to advance liberty, to make sure one branch doesn't go too far, and to make sure the rights of individuals are vindicated. And as sort of Steve recounted with some examples, you can sort of very quickly see how these really abstract separation of powers principles about who gets to decide things, who's the right actor for something, can very quickly have very real-world consequences for what can a particular administrative agency do vis-a-vis a large number of people. So I have always cared passionately about the separation of powers, but it's a hot topic, not just because it is a topic that increasingly affects people's lives, but it's a very hot topic on the Supreme Court docket in the last sort of 10 years. It's really the golden era of separation of powers challenges. So Steve and Jack have both sort of touched a little bit on Article 2 issues, and I think the sort of 40,000-foot storyline for Article 2 really is the court has given the president and Article 2 powers, sort of has defined Article 2 powers in a way that emphasizes the president's control. That is an obvious thing to say, just given the trend line for a lot of the cases on the president's duty and powers vis-a-vis control of who is in the executive branch, who is a subordinate, how can the president make sure that the people working for the president are faithfully executing the president's objectives. These are the sort of cases about who can be appointed, in what manner, what kind of sort of officer of the United States are you, and how can you be removed? And the area of law gets really technical, but the big principle really is how can the president and those who are heads of agencies or otherwise sort of one level below the president make sure that there are checks within the executive branch so that it's sort of a unitary system that is all responsive to the president. That's the kind of question the court's addressing in those cases, and the court's opinions have very much emphasized that principle of accountability being really important. 20 or 30 years ago, you would kind of see more debates in the Supreme Court about, is it okay if it's sort of functional checks or abstract checks? Now the Supreme Court has trended much more to sort of a formal sense of the buck stops with the president. The court has used that line in sort of multiple opinions. And how does that sort of cash out vis-a-vis who is working in the executive branch and what counts as being part of the executive branch? So in that sense, it's correct to sort of see the court's cases as a real emphasis on control and accountability. The flip side for Article 2, though, is that the Article 3, the courts have been more skeptical of what the executive branch can do. And in addition to Loper-Bright and the demise of the Chevron doctrine and the Supreme Court saying that it is courts and not agencies who are ultimately the interpreters of statutes. And in addition to cases raising questions about how can Congress delegate powers to agencies? How clear does it have to be? Can agencies sort of assert broader powers without clearer congressional commands? Some questions, the so-called major questions doctrine and non-delegation doctrines. I just also flag one more area that is getting a lot of play in litigation right now, which I'm not commenting any specific litigation, but just a fact in the world. The Supreme Court has said that there are constraints on what administrative agencies can do vis-a-vis the types of penalties and types of adjudications they're allowed to do. And this has spawned a great deal of litigation, much of it in the lower courts right now, but just sort of big picture questions about, are administrative agencies doing too much, too many things, too many types of things, too many types of remedies that should really be done by Article 3 courts? And that continues to be a big question, and I think is a looming question in light of some recent Supreme Court decisions. So I would just end by saying sort of who benefits from this. It's not just the executive branch in terms of clarity about what types of controls are permissible in the president's dealings with subordinates and who's part of the executive branch. But there's also a sense in which Article 3 has become like the courts have become a very, very powerful actor in this process, because a lot of the constraints on Article 2 come at the sort of the benefit of courts then being the ones who say what the law is on statutes. Courts potentially being the ones, as opposed to administrative agencies, that are trying to resolve particular types of questions. And courts, at the end of the day, obviously playing a very important role in all of the things we're discussing in defining what the ultimate metes and bounds of a lot of these policies might be. It's an active time for courts. I'll leave it at that.
Thank you. That wasn't boring at all. I didn't see anyone checking their
You
phones.
don't have to say that.
I have a few questions. Let me pick up with the theme, the separation of powers theme that especially Sarah hit on. So to my mind, the framers designed our separation of powers with Congress is envisioned to be the most powerful of the three branches. It's Article 1, after all. They had to pick someone to go first, but Section 8, Article 1 gives tremendous power to the Congress to regulate commerce, tax, declare war. But I think it's true in modern day separation of powers world that the presidency, the executive branch, has become the most powerful branch of government. So tell me if you think I'm wrong. Law professors are always happy to tell judges they're wrong. So I know this panel won't be shy. But if you think I'm right, are there certain inflection points over the last number of years where the presidency was sort of sealed as the most powerful branch? And is there a path to return power to Congress? Maybe we don't want to, maybe we do, but is there a path for Congress maybe reclaiming its post?
I agree. It's not because structurally Congress is not powerful, because Congress can be powerful. But what the founders didn't really foresee, I think, and what's certainly accelerated in the 21st century, is the rise of partisanship on the front end. Then partisanship goes back to the first, the Washington administration, but also to the point at which the president has become the leader of a party. And so in every presidential administration, whatever the structure is of Congress, there is a large number of people in Congress, maybe even majorities, as often is at the beginning of an administration, who are on the president's team and on the president's side. And over the last 25, 35 years, that has become a really dominant feature of American politics. And used to be you would have, committee barons on, congressional barons on who would run committees, and they would regard their committees as very important, almost quasi-executive actors in the system of government and putting forward legislation and the like. But these days, you don't see members of Congress speaking vocally for congressional prerogatives against presidents of their own party. You see people, they'll fight the opposing president, and they'll fight hard against the opposing president to prevent his agenda. But you don't see, you see negotiation, and I don't mean to sort of sell out, the very, able members of Congress who are out there. But as a general matter, they're on the team of the president, and they work together with the president. The result of that, I think, is two things. One, particularly given the filibuster rule, big legislation rarely gets passed because we haven't had situations, or other than perhaps a fleeting period at the beginning of the Obama administration in which you actually had 60 votes in the Senate. And so Washington being what it is, Congress is very good at spending money. They do confirm nominees, appointees, and then from time to time, when there's no other choice, they actually adopt large legislation. But most of the time, you have paralysis, and in the face of legislative paralysis, you've had an executive who has been, very grasping, in part because people look at the president to solve the nation's problems. And that's part of why you have administrative agencies with these very bold and ambitious agendas, which the courts have correctly cut back on in the name of not only judicial power, but actually that the idea that Congress is the one who's supposed to do that. But so that's my sense of agreeing with your premise that the executive has been the affirmative actor in our system of government, particularly in recent decades.
I'll just say two or three things. First, I generally agree. Congress still does. First of all, the presidency has been important, much more, I think, important than many of the framers thought from the beginning, and increasingly so from the beginning. Two, the president's current power rests to a large degree on statutory authorizations from Congress, many of which are vague, which require or are underspecified, which require aggressive presidential interpretations, which have been the subject of so much dispute, but many of which are not. I mean, the reality is that Congress has a lot of power that it has transferred to the president, sometimes specifically, sometimes not. Third, I would say, and Congress still is in the game of passing important legislation. Every year, the National Defense Authorization Act is a massively consequential law that gets enacted. Tax bills regularly get enacted, but Congress is not in the game in other contexts the way it used to be for a whole bunch of reasons, some of which Steve mentioned. The fourth thing I'll say is I think courts are in charge, not president. Because it's courts, yes, the president is taking an aggressive role in making law in this country when Congress used to. But it's the courts ultimately that have been deciding how much the president can do this. The courts have been pushing back on. This was your point, I think, or part of your point, Sarah. And ultimately, we have a government now where law is made by a dialogue between the two branches that weren't supposed to make law, the executive branch and the courts. And the courts have had the ultimate say, and they have been dramatically changing the executive branch, the scope of the executive branch's power, in some respects enhancing it, in some respects contracting it. Obviously, it's a dialogue. Presidents do things that force courts to react. But I would put the courts up there as also being hugely consequential.
I'll just make a pitch also in terms of the moment in time we're at, where I think you have to kind of zoom out, because right now it is a truism. Congress is not passing the kind of massive, ambitious legislative objectives that were passed, like say in like the middle of the 20th century. Like that's factually a truth in the world, obviously. And so I think we're kind of starting off from a point in time when Congress has accomplished so much in terms of legislation that expanded just conceptions of what Congress might have been able to do. And the goalposts are where they are in terms of what Congress has been able to accomplish. And I think it's kind of important to just sort of start with that recognition. It's not so much that Congress is sort of like the weak party in all of this. It's that historically the executive has been in a weaker position, or sort of received less attention in terms of the sort of scope of executive power. And Congress has gotten a number of opinions from the Supreme Court, just sort of looking at a broad time horizon, that have recognized very, very broad congressional powers, Commerce Clause being a prime example. And so it's sort of hard to say like who's in charge now, because the window of what Congress can do has shifted a lot in the course of the 20th century. One other actor we haven't talked about at all, because it's not part of the federal government, but states are, I think, increasingly important. Just in terms of who benefits when there is a decision that says federal agencies can't do a particular thing. Sometimes the upshot is this is something reserved for the states, or something the states need to be more involved in. And so I don't think there's like a right or wrong answer in terms of, I mean, this is just a reflection of like our system of government. Like you can make a case for most actors having really important roles in really, particular areas, but it's a dance, and that's the design.
Yeah, I think the state point's an excellent point. In some ways, the lawmaking process has really become executive order, state lawsuit, court decides. And so I know we have a lot of members of the AG's office here in Florida in the audience, and it's sort of hard to understate the role that states are playing now in bringing issues to the courts. We have sort of 25 Republican states, 25 Democrat states. There's always lots of willing plaintiffs out there. Do you want to add something?
Yeah, no, I 100% agree. I mean, when you talk about what is the legislative process that we have in most instances, because when you think of the controversies in the Biden administration, some of which I mentioned kind of in my opening remarks, and you think of like, how should we, how if at all, how should we regulate auto emissions or power plant emissions, or how should we regulate cryptocurrencies or the like? These are all basic, important, legal questions that one would think that if there's an answer to be had, like Congress could just pass a law and do this. They could update these laws. Should we have net neutrality? Well, maybe Congress should pass a law and decide whether we should have net neutrality. But what's happened as a practical matter is that the executive branch has sort of tried to answer these questions through broad statutory delegations that were passed, 100 years ago in many instances, 80 years ago, or the like. And then you have the regulation, and then you have the lawsuit by the states, and the red states, like the great state of Florida, were very active in the Biden administration, and the blue states now are all excited because they've got something to do, just like they did from 2017 to January 2021. And then even the courts change, right? I mean, we saw how busy the Fifth Circuit was over the last 4 years. Well, Fifth Circuit's going to be less busy, over the next 4 years. And apparently the First Circuit is the initial circuit of choice, so the Ninth Circuit will be busy as well. But you do have this system in which whether or not we adopt these policies, which would be quote legislative, is done precisely as Judge Readler said, by first executive action, then lawsuit, then court decision, and then also states being able to fill in the gaps. I mean, as Florida has seen with Florida actually is passing laws, and Florida is addressing the problems of the people of Florida. And the same could be said, whether they're addressing them well or not, for the people of California or the people of New York, where those legislatures actually pass laws and the like. They happen to be generally bad laws, but but that is what it is. But this, so the states do play a very important role, with respect to their population.
Can we talk for a minute about executive orders? So obviously that's been sort of the predominant news story the last couple of weeks, other than the tragedy at DCA. And that was probably true to some degree at the start of the Biden administration as well. So we hear a lot about executive orders, but I wonder, since we have experts here in sort of writing and understanding them, is every executive order self-executing, or do these executive orders really rely on other people in the executive branch to carry them out? Does that mean that sort of when we hear about an executive order, that its actual sort of implementation and effect may be delayed even by years? As you're all experts, can you just give us some sense of what an executive order is, and are they all created equal?
Yeah, sure. So generally speaking, executive orders come in two flavors. One set of executive orders, and perhaps the majority of executive orders, are basically directions from the president to his senior officers. And what the White House is doing with those executive orders, I think, is two things. One of which is setting priorities for the departments and agencies. The president is formally publishing a document which says, here's what I want, Madam Secretary of Homeland Security, here's what I want you to do, on the border and on immigration, or to the Secretary of Defense or the like. And so they are setting priorities, directing action, and sort of forcing the departments, to take that action. And so they're also performative in the sense that they were publicly declared, and President Trump was, very public in signing his executive orders, on day one. These are the priorities of my administration. This is what I expect the departments and agencies to do. And then when the departments and agencies, when the cabinet heads receive these orders, they generally carry them out. But they must be carried out, by the recipient, and it's not actually direct presidential authority other than the president's authority to supervise the executive branch. There is a second set of executive orders in which the president actually activates statutory delegations. And so, and actually I haven't read the latest news, but President Trump has been talking about tariffs on Canada and Mexico maybe as soon as, as today. The president has very broad delegated statutory authority under a number of statutes to actually set tariffs in a variety of different contexts. Some as sanctions for international emergencies, and some others under various delegations. And so those executive orders, those proclamations, actually have the force of law. They're not inherent actions of the executive in the sense that the president can do it on his own, but he is activating statutory delegations, through those executive orders and proclamations. And those, have essentially the force of law that can affect, not parties outside the government.
I'll just add to that something that probably everybody in this room knows, but some people don't know. Executive orders themselves do not create legal authority. They all rest on prior authority, either from Congress or the Constitution. And typically an executive order will say, based on my constitutional and statutory authority, sometimes treaty authorities, I hereby do X. So I'll just add that they're not in themselves, technically they don't add to the president's power, they're drawing on the president's power.
Well, I talked a little bit at the beginning about the job that you do in OLC, and so I'm just wondering if you could give us some anecdotes or just add some color to what it's like to give legal direction to cabinet secretaries who are themselves confirmed by the Senate and have pretty high-ranking jobs, and to the White House, to the president, to give legal advice that it's presumed they will follow. Sarah, this might be harder for you to discuss, but I don't know, any of our panelists want to talk about the job of running OLC or being in OLC?
You want to go?
It's a good job.
Very good job.
It is. OLC has traditionally performed a pretty critical role within the executive branch because the president at the top takes, faithfully executes the laws, and everyone needs to figure out kind of what the law is. And well, these days, many of these questions will wind up in front of a court sooner rather than later. Not all the important questions that the executive has to to deal with do in fact wind up in courts. Some are non-justiciable, some are national security matters that are not public. And so it's very important that there be a centralized way of sort of figuring out kind of what the law is for the executive branch. And traditionally, the Attorney General was given this statutory authority at the very beginning of the Republic in the Judiciary Act of 1789. But since the Attorney General is now a busy man or woman running a giant bureaucracy, that has been delegated for almost a century now to the Assistant Attorney General for the Office of Legal Counsel. And so, OLC is brought in when there's disagreement within the executive branch. It's also brought in, I think, when there are certain OLC-like questions, including many of these questions of executive power that we're talking about, that the White House or the cabinet secretaries want to sort of deal with on the front end. And so, the office has about 25 attorneys, many of whom are there across administrations and become kind of experts in their particular areas of law. And what makes OLC tick is generally the support given by the White House counsel, and the Attorney General, and the fact that it's often convenient for many departments and agencies to be able to point to someone outside of their department of agencies in deciding what their legal authority is, particularly if the answer is going to be you can't do a certain thing. Then it's easy to blame OLC, and it's a mechanism of accountability or whatnot.
Yeah, I agree with all that. I'll just add three little things. A lot of OLC's advice, one tends to see OLC's work product in terms of opinions. Those opinions are in some sense not representative of the office's jurisprudence, because often the office advises no or no like that, and then that's based on a preliminary analysis, and then there's no opinion written. So the opinions themselves, although they constitute the jurisprudence of the office, can be misleading about the work of the office. Second, for 4 points, the OLC often gives a lot of informal advice, at least they did when I was there, that didn't rise to the level of formal opinions where the White House or a department is thinking about doing something and they just want a gut check about, are there any obvious problems to this? We're not asking for a formal opinion. You're the experts on this. Let us know what you think. A decent amount of the work of the office was that. Third, the office reviews executive orders for form and legality. This is an important function of the office, although the form and legality process is itself its own hard-to-describe beast. And for the office, again, I was there a long time ago, comments on bills of Congress looking for constitutional issues and infirmities in bills enacted by Congress, with an eye towards either trying to fix those problems in incoming congressional legislation, or to advise the president that the president might want to, through a signing statement, make note of the unconstitutional or possibly unconstitutional provisions in the statute. So there's some other small bore things that the office does.
And I guess I'll just jump in from like a historical matter of just having worked in OLC as well. The things that I didn't realize OLC was involved in, because I think everyone does try to think of it as like OLC issues opinions for the executive branch, and like that's what people outwardly see. But there's also, the office is very involved in relations with Congress. So especially in divided government, like the office plays an important role in developing a jurisprudence of like executive privilege and these kinds of things. And they're like the world experts on that, and in a very helpful way to the executive branch often. And then there's sort of other things the Department of Justice does, like rulemakings, or the Attorney General has authority to issue immigration opinions by statute. And so there are these things that in different administrations can really loom large in terms of things that OLC may or may not be doing. And the mix of things that OLC does, I think it's fair to say, like changes from administration to administration. But the bottom line is the office does just sort of historically do many more things than you might think at first blush. But they all relate to how should the executive branch do a particular thing, and who can they turn to for advice on that thing? Often it's just call OLC.
Can I just add one slight point, building on what you said? Every presidency potentially uses OLC and advice from the Justice Department and from OLC differently. The Obama administration kind of diminished the role of the Office of Legal Counsel and had more of a White House-centered process The Bush administration I worked in, and I believe the Trump administration had more of a DOJ, OLC-centered locus of advice. I will say it's not clear to me yet how the Trump administration is organizing its receipt of legal advice. I think that's an issue we have yet to learn about.
Sir, I don't know if you want to add anything about the SG's office and their general role. I'm not going to put you on the spot, but I'll just say as someone who was in the litigating division at the department, really the two most important offices in the department, with all due respect to the AG and the DAG, were OLC and the SG. Because OLC, as you've heard, was trying to spot legal issues and correct them to the best of their ability before a policy went into effect. Once a policy went into effect, there'd be litigation in the civil division or environmental natural resource division or another litigating division will be handling that. But the SG's office then was very involved in active litigation, in part because if something went to the Supreme Court, of course, they'd be arguing the case, but in part because no lawyer in the Department of Justice, whether it's the head of the civil division, whether it's the U.S. attorney in the Middle District of Florida or somebody else, no one can take an appeal in a governmental case from the district court to the Court of Appeals without the permission of the SG's office. So the SG's office really controls which cases get appealed and which circuits on what issues. They really control how issues get up to the Supreme Court. And then, of course, they argue the cases once they get there. So their job is more than just arguing in the Supreme Court. Happy to have you add to that or remains.
That is a correct reflection of the DOJ regulations governing the SG's role.
Great. All right, I passed the test. So we talked a lot about the presidential power. One thing that I think has been interesting about sort of modern presidential power is the use of soft power by means of persuasion or threat. In the last administration, the Supreme Court decided the Murphy case, which reflected on the Biden administration's efforts to jawbone, coerce, encourage social media companies to not post certain content on their platforms. President Trump certainly uses these authorities a lot much more, I would say, overtly through tweets and other things, harassing the president of Colombia to accept their citizens back or harassing members of Congress to vote for his nominees. So I think we've seen a big rise in the use of what I would call sort of soft power by presidents, short of actual formal action to accomplish things they'd like to see done. So any reflections on that trend? Is it important? Just love to hear from the experts.
I wouldn't say harassing. What we've seen from President Trump since the election is really remarkable. Frankly, even prior to January 20th, I've never seen, a president-elect, or maybe even president, put the country on such a real power shift, a real shift in priorities that President Trump has brought, and much of which he did without using any actual powers of the office, in the interregnum between the election and January 20th. And, when you see Inauguration Day and you see the lineup of folks who were there, the leaders of, major companies, around the country, and folks who have sort of on their own voluntarily announced policies that are consistent, with the policies of the Trump administration. I think it's about the hardest soft power that I've ever seen exercised. And so I think clearly historians of the presidency used to talk about this and about the presidency being the power to persuade and the impact of Franklin Roosevelt and others kind of out there. Kind of using what Teddy Roosevelt called the bully pulpit, and to some degree, perhaps that had sort of declined over time. But I think with the advent of social media, and the like, it really has magnified the powers of the presidency.
I generally agree with that. Don't have much to add. It didn't start with President Trump, and as you said, the bully pulpit idea started with TR. And the use of social media, if you look at even the Obama administration and then in the late Bush administration, they were starting to use social media. Each administration, I'm not sure about the Biden administration, but has gotten better and more adept at using these communicative powers, direct connections to constituents as a way to circumvent other forms of opposition and to shape agendas. And it has been remarkable how President Trump has used that power in the first 2 weeks.
Yeah, I think it's sort of a broad historical issue. Every time there's a newer technology, be it radio, television, there are some presidents who are particularly adept at using those methods to communicate with the people and finding ways of, creating just a sort of direct relationship with people to announce policies, et cetera. And presidents, like any other power, use that particular lever of communication with more or less skill. And so I think this is just sort of consistent with the way it often just works throughout the 20th century. And we now have social media, which has very much changed access to a large number of people at once. And we'll just have to see what happens next. What comes after that?
Sure we will. So I'm going to ask one more question, but then if anyone in the audience wants to ask questions, we have a couple of microphones here on each side. So I think it was Jack who talked about the role that courts play in, of course, in the separation of powers, and maybe there's been some rise in the courts. And if we look back over the last couple terms from the Supreme Court, there are significant decisions, Celia Law, Jarkissi, Loper Bright, that address the separation of powers and in some ways have cut back the power of the administrative state and the executive branch. So can you sort of comment maybe on those cases and what effect they've had on maybe curtailing executive power or maybe not?
Me?
Any of you?
Yeah. You talked about those cases. I mean, in your opening remarks.
Yeah. No, I mean, I think, again, I mean, I think you do see, I mean, with respect, I mean, the common theme, and I talked about how, on the one hand, we've seen the unitary executive branch. On the other hand, we've seen the curtailing of executive power with respect to the administrative state. I think one dominant theme in the Supreme Court's jurisprudence has been cutting back on the powers of administrative agencies in the name of separation of powers. I mean, we have the separation of powers to protect liberty. You have administrative agencies that developed over the course of the 20th century, basically conflating all of the powers. You know, they wrote the laws through regulations. They decided who to investigate, and in many cases, they had their administrative judges in there to decide who violated the law. And like, while parties theoretically could eventually get to the Article III courts, you know, most parties don't have 2 years and millions of dollars, in legal fees to sort of finally get, out of that, behemoth. And so we've seen, real shift driven by the Supreme Court in enforcing the separation of powers and, kind of restoring, that balance in a way that cuts back on the administrative state, although it has increased the president's personal control over the executive branch.
I guess I see this area too for courts as courts have gained power in some sense because they are now adjudicating things or addressing matters or deciding questions that previously the executive branch had been deciding. But at the same time, I mean, the Supreme Court has been has a long line of cases constraining like Article III standing, like the idea of who can be in court. And so there's also this sort of same dynamic of there might be sort of an additional power or consolidation over what courts can do. But at the same time, courts are being very circumspect in a lot of these cases. And there's sort of looming questions on this about the limits of it, about who can be a litigant before Article III courts. And the trend of the Supreme Court cases in general has been to tighten who's allowed to sue any particular matter.
Okay, I think we have some questions over here.
Hello. I was really interested by your discussion of the Trump v. United States holding that the president essentially has unfettered discretion to investigate and prosecute crimes and the implications of that. You brought up the TikTok case, which is interesting because there's, from my understanding of the act, there's both civil and criminal penalties. So I assume that you were talking about both, that you understand the implication of United States v. Trump to apply to civil actions as well for penalties. And I was wondering if you could also talk about that sort of discretion might have like very broad implications, as you said, about all kinds of presidential discretion. So, the Impoundment Act comes up as an example that might be very...
Just make it a tighter question.
Yes, sorry. So one, you are saying that the US v. Trump holding applies to civil actions. And then two, does the US v. Trump holding have implications for presidential power over spending?
So I'm saying, yes, that even though the court was talking about prosecutorial discretion, the court's cases that talk about prosecutorial discretion rely on the take care clause. They also are the same cases that and this take care clause citing the criminal cases in the civil context. So the source of presidential discretion to enforce civil law seems the same, and even though the court did not rule on that issue, I'm not saying it inexorably follows from Trump. I'm saying it is an open question whether, and typically, if you read these cases carefully, the court has said the president has broad discretion to enforce the law. But for example, in United States versus Texas, it said, but if the president stopped enforcing a single law altogether, that might go too far. Well, I'm not sure where that line is now after Trump versus United States. And yes, too, I imagine that in the spending clause case, this argument will be raised. I'm not sure it will work, but I'm saying there's ammunition now in these cases that didn't exist before.
Thank you. Next question.
I actually think Trump versus United States cited Heckler versus Cheney, which actually which is a civil enforcement
Civil
case,
enforcement case, yeah.
actually, for this proposition.
Yeah, exactly.
So I want to ask a question about President Biden's impairment, and was there a shadowy group running things and, basically like some sort of ventriloquist, exercising executive power? And the question is, would the 25th Amendment be the only way to deal with that? Or, for example, could people have challenged the ban on export of liquefied natural gas by calling Mike Johnson as a witness and saying the president had no clue about what was going on? So there wasn't really, this is invalid inherently because the executive didn't really do it. But just any of your thoughts about, we haven't had this since Woodrow Wilson with what happened with Biden. And what do you think about it?
Well, I think Sarah's going to sit this one out, I'm going to guess. But I don't know if I'm going to also. I don't know if anyone else wants to.
I don't have an informed view about that. I think it would be hard to bring a case against, the court would probably deem it a political question, bringing a case saying that a presidential order is invalid because the president was mentally incapacitated. I don't think that kind of lawsuit would work, but I could be wrong. So I guess I do think that the 25th Amendment is the remedy there.
It sounds like it would have been a good idea to bring that lawsuit, but it may be moot now. But no, actually, I'll just say something like recognizing that I don't know anything about, I haven't met President Biden and nobody's confided in me about his condition. But I actually think, but I think the way the executive branch works, the way the White House works, is actually slightly different as a general matter, which is whatever the state, the fitness of President Biden, whether he's a secret genius or whether what we saw in the debate is bread and butter. When the president is in the room, the president actually makes the decisions. And there are people who sit around him and they all have different views and the like. Maybe the president listens, maybe he doesn't. But at the end of the day, somebody's got to make the decision. And so as, putting aside a particular regulation or whatnot, which I guess technically is made by, the departments and agencies typically rather than the president. Like I actually think, for better or for worse, the president is the one who actually probably puts the direction on things, even as he has advisors who, channel what's presented to him.
Okay, next question.
Thank you all. I'm wondering how you think these separation of powers issues cut on the private non-delegation doctrine. So as I understand it, it's always been sort of justified several different ways, some due process rationale, maybe some stuff about Article 2, but it's not been entirely clear. I think in the last 20, 30 years, maybe you've seen more people start to root the private non-delegation doctrine more firmly in Article 2. I'm thinking of the Amtrak concurrences by Justice Thomas, Justice Alito. Judge Newsom here in the 11th Circuit wrote an interesting opinion in Consumers Research. So just how are you thinking about the private non-delegation doctrine in terms of separation of powers? And, to put a bite to it, isn't it sort of odd that the current remedy for a private non-delegation doctrine violation seems to me like it just makes the private entity an inferior officer, but then they're not appointed.
Go ahead.
Yeah, no, I totally agree. I mean, I think the private, as I take it, we've seen a real increase in private non-delegation cases, and there have been cases involving the horse breeding statute, the Horse Breeding Association out of I think it's the Fifth and the Sixth Circuits, and the like. And so, I think. While there is a due process type issue, I think very much there's an Article 2 issue. And when we talk about the Appointments Clause, what we're talking about is accountability, right? The Appointments Clause ensures that the officers of the United States are directly or indirectly responsible to the elected president. And so if you don't have that, and if there's a problem because private organizations are not appointed consistent with the Appointments Clause, those decisions should be subject to challenge and vacatur and the like. And I think I think it's all the same stripe of the courts taking the separation of powers increasingly seriously.
I just add to that, that a cousin of this idea, the court has increasingly insisted, and this is an analogy, it's not perfectly on point, but in the standing context, the court has increasingly invoked Article 2 as a reason to not allow Congress to delegate, absent concrete injury, enforcement of federal law to private parties. And it's not an Appointments Clause issue, it's a Take Care Clause issue, but I think these ideas come together.
And thank you all for being here. My question is about the seemingly international trend away from globalist engagement and policy and more of a focus on national priorities. How do you see, obviously that's happening here in the US and it's happening in Europe and South America as well. How do you see that at a large level driving more power to the executive or creating a response from administrative states to try to take the power away from the executive?
Can you give a concrete example?
Sure. So in Central America, you have Bukele, who's consolidated a lot of power. In the US, obviously Trump is, as you previously discussed, using the bully pulpit in a little bit more of an aggressive way and trying to consolidate a little bit more power to deal with the issues of the administrative state in the US. So I guess the question is, at the WEF, for example, they just announced that they lost against Trump and that Trump's return to office was a defeat for their policy proposals and their view of how the future would work. So I guess the question is, do you think executive power, not just in the US, but around the world, will continue to take more from the administrative state or not?
I'm afraid I don't have an informed view on that question. I'm not sure I understand the question. I apologize. Do you have a view about it?
Yeah, no, I mean, I think when we talk about the administrative state, in the U.S., we're obviously talking about a system of government and the way in which agencies fit within our, separation of powers. Obviously, a number of other countries have very different structures. And when they're on parliamentary systems and the like, and so the relationship between the head of the government and the bureaucracy can be very different. So I think it's hard to generalize. I think part of what we're seeing though is the increase in channels of mass communication with social media and the like is strengthening the hand of those with the largest voices. And it wouldn't be surprising if in many cases the head of the government has the largest voice, in a particular jurisdiction.
I'll just say one thing idea that was provoked by this idea. That's not a direct answer. I don't think we should assume, this might not be good news for this room. I don't think we should assume that all or most of President Trump's assertions of executive power in the last 2 weeks are going to prevail. I'm not at all sure they're going to prevail. And so I think it remains to be seen, exactly where executive power stands in this country in 2 or 3 or 4 years.
Sarah's confident that it will prevail.
I wasn't doubting Sarah's acumen. I'm just saying I won't comment anymore on the tasks Sarah has ahead.
Well, we can all gather next year and check in and see how things are going. But please join me in thanking this really terrific panel.